Well, welcome everybody to World Arbitration Update. It's day 5, September 30th, 2022. We're very pleased to offer you this, our second World Arbitration Update. It's been a fantastic week. We've had, I think, over 15 panels already, a huge variety of topics, some great people presenting. And so thank you to all of our moderators and presenters. It's just been a great week, and today should be a nice cherry on the icing on the cake, cherry on the sundae, however you want to say it. And before I get to today's panel, I just want to cover a few administrative matters. First is to thank our sponsors. We couldn't have done this conference without them. They've been incredibly supportive, and we need to give them full thanks for all their contributions. We have also a great group of supporters. We've listed them on our website, and of course, our advisory board has played a critical role in shaping our panels and the overall conference this year, and we're very grateful to them. I guess I should introduce myself. My name is Ian Laird. I'm a partner at Crowell and Mooring here in Washington, D.C. I'm co-chair of World Arbitration Update along with my colleague, Dr. Jose Antonio Rivas, and Dr. Rivas will take us into the session. But before that, I just wanted to talk a little bit about World Arbitration Update and kind of the objectives that we've sought to meet in creating this conference. And the first objective is, of course, to provide a very accessible, open forum for the reporting of new developments in international arbitration. The virtual method, which has grown up over the last few years with the pandemic and so forth, has become a great means to connect to the international arbitration community. And also it's played helped to play another role, and one of the key objectives of WOW is to reflect the full diversity and incredibly varied nature of the international arbitration community. One might think that international arbitration only occurs in New York or Paris, but in fact, the practitioners and the people involved in the international arbitration world hail from every corner of the planet, every country, every region. And we've sought to reflect that in the way we've structured the last 5 days by having panels and individuals from every part of the planet, and to fully reflect the incredibly diverse nature of international arbitration. We thought that was very important to create a conference that very much celebrates that diversity. Today's panel is one that really goes to the heart of, I think, the mandate to update folks on developments in international arbitration. Some of the biggest developments have been occurring in the investor state arbitration world. We've seen new rules promulgated at ICSID, and we'll have a panel at noon today DC time, so looking forward to that. But also we've seen an incredible output of activity and energy and innovation occurring at UNCITRAL, and today's panel will be looking at those developments. So before I pass over to Jose Antonio, I just wanted to reflect on the incredible work done by X-Strategy and Anna and Maria Lucia in particular, for their incredible support and hard work in making the conference the success it is. Without them, it absolutely wouldn't happen. So full congratulations and commendations to them. So on that note, I just want to pass it over to Jose Antonio, and we'll launch ourselves into this fantastic panel. Jose Antonio.
Thank you, Ian. And as indicated in previous panels, this is a team sport, and we're very I'm very glad that we're partnering with you and in this venture that is for two objectives. One is to update on issues of public international law, investment arbitration, and international commercial arbitration, and two is to decentralize international arbitration. And what other better panel than this? I mean, this is the heart of the discussions of the investor-state arbitration or dispute settlement system, UNCITRAL Group 3 discussions. In this panel, we have, and this is part of the job of our incredible moderator, Margie-Lise Jaime, but I cannot stop myself at saying how glad I am of having Anna Joubin-Brett, and also individuals new to WOW, Ekaterine from a academic perspective, given her writings on the subject of public international law and multiple treaties or plurilateral treaties, and how the investor-state arbitration system plus MIC, multilateral investment court, might lead to some level of fragmentation. To have Lauren as well, Lauren Mandel, from the perspective of the views that possibly chambers of commerce and businesses in investment arbitration might have, and Margie and of course Maria Lucia, who will be the presenter. But saying that, let me emphasize and present our moderator. Margie-Lise Jaime is senior advisor at the Ministry of Economy of the Republic of Panama. She is the representative of Panama in the UNCITRAL Group 3 meetings, and she is basically the present in investor-state arbitration, and I'm sure the future for the Republic of Panama. We are very, very glad to have Margie here for many reasons, not only because of her posts, but also because of her background, and you'll see what I mean. She has a PhD. She's a fellow of the Charter Institute of Arbitrators. She's a professor of law at the Universidad de Panama, and she has been acting as a consultant and expert in commercial, trade, and investment matters. Her practice has included international litigation, maritime disputes, commercial arbitration, investor-state disputes, and international trade. She received her PhD and LLM in International Economic Affairs law from Université de Paris 2, Antio-Assas, and an LLM in arbitration and international business law from the Université de Versailles. She also has an LLM in international business and economic law, and from Georgetown University, my alma mater, and where we teach. So she really is somebody who, from practice, academic and life experience, can share a lot. Margie will not only be the moderator, she will also be providing commentaries, substantive commentaries. So she will be playing both roles, and we're very glad to kick this off. As you know, this session will be recorded. I am now authorized by our developer and also partner in this venture of an application, Disruptica, to announce that we will be not only recording all the panels, but in the near future, hopefully before the 10th of October, we will be able to, or you will be able to, look at the videos, but also term search them for researchers, for everyone. So normally it's kind of boring to go into a website and see 2 hours of a video, but now you can go right where you want. So with that said, welcome everyone, and take it away, Margie.
Thank you, Jose Antonio. And well, I would like to start by thanking the organizers of this panel and this wonderful week of World Arbitration Update. It's really an honor to participate for the second time to these sessions. So our sessions, it's UNCITRAL Working Group 3 and Fragmentation of ISDS. And I hope that it's going to be, a very dynamic and provocative for all of you. So as Jose Antonio started mentioning, Maria Lucia Casas is going to be our presenter. So she will provide a general overview of Working Group 3. Maria Lucia Casas is a Colombian lawyer and a specialist in renewable energies and energy efficiency regulation. She is currently Senior Associate of Arbitration and International Law at Strategy, a boutique law firm based in the United States and Colombia. And she is also Assistant Professor of International Public Law at the University of El Rosario and coach of the Philip J. Moot Court competition of the Universidad El Rosario. Then we're going to have a dynamic panel that is going to discuss all issues related or our discussions in Working Group 3. And we will start with Anna Juvan-Brett. She, as everybody knows, is Secretary of the United Nations Commission of International Trade Law, UNCITRAL, and the Director of the International Trade Law Division in the Office of Legal Affairs of the United Nations, which functions as the substantive secretariat for UNCITRAL. Prior to her appointment on 24 November 2017, Anna practiced law in Paris, specializing in international investment law and investment dispute resolution. She focused on serving as counsel, arbitrator, mediator, and conciliator in international investment disputes. Prior to 2011, and for 15 years, Anna was the senior legal advisor for the United Nations Conference on Trade and Development, UNCTAD. Anna holds a postgraduate degree in private international law for Universidad Paris 1, Panthéon-Sorbonne, a master's degree in international economic law from Université Paris 1, and political science from the Institut d'études politiques. We will have also Laurent Mandel. He's specially counseled in the international trade and international arbitration groups at Wilmer Hill in Washington, D.C. In practice, Laurent represents investors and sovereign states in investor-state dispute settlements, in addition to advising on investment treaty negotiations. And prior to joining Wilmer Hill, Laurent served as in the U.S. government, and most recently as the Deputy Assistant of the U.S. Trade Representative for Investment, the Principal Advisors to the U.S. Trade Representative on Investment Law and Policy. Today, Laurent represents the U.S. Council for International Business in the UNCITRAL Working Group 3. The USCIB is an association of international companies from every sector of the economy dedicated to promoting international trade and investment. And last but not least, we'll have Ekaterine Florul. She is a lecturer in international economic law at the University of Liverpool. She is also an adjunct assistant professor of international investment law at the Fletcher School of Law and Diplomacy and the general editor of the Journal of the World Energy Law and Business. Before joining academia, Ekaterina worked for several years as a legal and policy officer at the Energy Directorate of the European Commission. She's also been a consultant with the OECD, the Columbia Center on Sustainable Development, on Sustainable Investment, and the tutor at the Hague Academy International Law. Katerina is member of several fora of international investment law and international energy law, including the Academic Forum on ISDS and the Association of International Energy Negotiators. So we have a panel of experts on the topic. So, well, and now we will start because the time is passing, and we will start with Maria Lucia Casas, who is going to be the broad presentation of Working Group 3. Maria Lucia.
Thank you, Margie. Thank you for the kind introduction. And of course, thank you to Jose Antonio and Ian for inviting me. It is a real pleasure to be here at the last day at WOW, and of course, to be sharing this panel together with Margie, Anna, Lauren, and Ekaterina. I must admit that it is a heavy burden to present a presentation of all of you, but I'll do my best to do a great update of this hot topic. So, well, to start with, the first thing that I would like to mention is that investor-state arbitration and, of course, ISDS reform is one of those hot topics that are currently being discussed in many forums. Particularly, of course, the fact that stakeholders and users of the system in the recent years have been identifying some shortfalls that have made them rethink the system and consider whether there is a need to renovate or to reform the system as it is conceived today. So some of the questions that today are in everyone's mind is whether ISDS is going to the right direction, or whether the creation of a multilateral investment court or an appeal mechanism is justified. And of course, if this may be the dead cost of an investment arbitration as we know it today. So in the past few years, and to be exact, it was in mid-2017, the world has been witnessing the investor-state dispute settlement reform debate under the aegis of the United Nations Commission on International Trade Law, more known as UNCITRAL. And as some of you may know, this discussion, of course, started when the UNCITRAL entrusted its World Working Group 3 with a broad mandate to work and to deliberate on the possible multilateral reforms of the system. So these deliberations, of course, are taking place based on many things or many issues. First, of course, concerns that have been identified of the system. And of course, also by the fact that some countries and regions nowadays are developing new approaches to dispute settlement. And for instance, are also examining other options for dispute prevention and are also trying to negotiate alternative types of bilateral investment treaties, or even renegotiating or trying to terminate its existing international investment agreements. And of course, you might know that this has happened within the European Union after ACMEA. So the working group 3, by discharging this mandate of UNCITRAL, it has really ensured that the deliberations and discussions that are taking place while of course benefit from the widest possible breadth of available expertise from all stakeholders. They have been leading by, of course, governments, and of course they have been doing so within consensus based, which is of course the more important in a dispute settlement system, as investor-state arbitration dispute settlement is. So, well, on the understanding that those possible reforms that are being discussed, and of course will be the topic of this panel, will be made applicable to the existing international investment agreements, I believe that it's important to put into the table or to bring into the participants' attention some of the statistics of the UNTACT that established that nowadays we have more than 3,300 existing international investment agreements, having 2,000 and almost 500 international investment agreements in force, whether they are BITs or other treaties, of course, with investment protections. So now entering into the subject matter of this panel. So which are the reform options that are being considered by the working group 3? So we have like big topics and of course subtopics that are developed in each of these big topics. So as a first topic, we have dispute prevention and mitigation and means of alternative dispute resolution. Here as subtopics, we can find issues regarding exhaustion of local remedies, procedures to address frivolous claims, of course, counterclaims, which is always a very interesting topic. As a second point, we have the selection and appointment of ISDS tribunal members. And here we can find discussions regarding the code of conduct for adjudicators, which we will be discussing that today. And of course, those issues regarding member selection, appointment, and challenges. We also have issues regarding cost management and related procedures. Of course, third-party funding, which is always a hot topic on these sessions. The establishment of a multilateral advisory center, which I really found a very interesting potential reform. And the last two, which of course are the more discussed in the international scenario, we have the suggestion of an appellate mechanism, and of course a multilateral permanent investment court. So the last working session of the working group 3 was held 2 weeks ago. So this panel, of course, is very pertinent since it took place very recent. It was between September 5th and September 16th. And it was very exciting, of course, because it was the first in-person meeting since the start of the pandemic. Just to give you like an understanding on how it worked this session, in this occasion, although delegates were able to listen the session remotely also, they could only intervene with comments if they were attending the session in person. So, well, as to the topics that were discussed, and of course, this is going to be the matter of this panel. We have the following topics. First, we have the standing multilateral mechanism, where we can find issues regarding selection and appointment of ISDS tribunal members and related matters. We also have multilateral instrument of ISDS reform. We also have those procedural rules and cross-cutting issues where we can find the issues regarding allocation of cost, counterclaims, third-party funding, and assessment of damages, which is a very important topic. And it is my understanding that regarding this topic, they have agreed a way forward to work on a draft text that will include some provision and guidelines and exploratory notes on issues such as speculative evidence, causation requirements, valuation methods such as the uses of the CF, which is a very complex topic. I'll leave that to the experts, and of course the proper valuation date regarding a pre and post award interest rate. Also in these subtopics, as I mentioned before, we have third-party funding, and some of the instructions that have been given to the Secretariat on this issue is to prepare provisions on some categories, such as to provide a broad definition of what is third-party funding, so you can ensure like an adequate disclosure and of course avoid with this any potential conflict of interest. Also to include a permissive rule whereby third-party funding will be generally allowed, but this will be limited by some conditions on the specific terms of the funding, such as to clarify that the third-party funder or its representative must not have control or influence over the management of the claim, and that the third-party funding must refrain to choose and to be representative by its own legal representative, which of course these are issues that are obvious for some people that work in the industry, but of course there is a need to clarify those aspects and to have like a clear rule on that. We also have some discussions about draft provision and guidelines on investment mediation, the code of conduct, as I mentioned before, and lastly, the advisory center, which I think it is a very interesting proposition, but of course, there is still a need to define clearly the scope of the services, who will be the beneficiaries, whether it will be for least developed countries, developing states, or states with limited experience in investor-state arbitration disputes, whether and in which scenarios conflict of interest may arise, its structures, its location, of course, and cost and financing, which is, I think, one of the great issues on this reform, how we are going to finance all these ideas behind the discussion. So as you can see, of course, this is a very ambitious process, one which our panelists will dive deeper into a few moments. So I think with that, and of course, taking into account the time, I'll yield the floor to Margie and to the experts that will enlighten you about the discussions that took place a few weeks ago.
Thank you so much, Maria Lucia. And by your presentation, it's clear that Working Group 3 has been really busy in the past 5 years. I recall, in 2017, when this started, that at least for me, it was clear that the question was not whether or not ISDS needed to be reformed, but how it was going to be reformed and how deep is going to be this reform. So, and that is what we are discussing, and we just passed 2 weeks entirely discussing on some of these topics. To talk a little bit more about that, Anna will touch on some of the aspects that we just discussed 2 weeks ago, which are the multilateral framework conventions, work on damages that you mentioned, Maria Lucia, the work in mediations and the importance of mediation provisions. And lastly, of course, the code of conduct that we have been discussing by, I don't know, at least the past 2 years, and modeling the draft of the code of conduct. Yeah, Anna?
Thank you very much. So at the outset, I would like to thank the WOW for inviting me and giving me the opportunity to share a few thoughts with you. And I wanted to start out by saying that I actually take a bit of issue with the title of our panel, because I don't think that we are fragmenting, but rather that we are trying to carry out, as you say, a very complicated and complex task of reforming a sophisticated system, and we're trying to do it in a coherent manner. So if we look at the various pieces, and of course you can already see where I'm aiming at, that they are indeed pieces of a puzzle, but that this puzzle is meant to be put together and to show a coherent picture. When we look at it, when all the pieces are put together, we will have a comprehensive and coherent picture. This is really what the working group is trying to do. And what I do, if you allow me, rather than spending much time on the different elements of this, the different elements of reform that Maria Lucia, you have explained so very well, so very aptly, and in so much detail, giving us really what what is needed, where we are in the development of all these reform elements. Now, before I do that, I would also like to talk very briefly about the process. We have since the beginning tried to have a very inclusive process, and also a very, or we've tried at least to be efficient, in the sense that we're not here to replicate or duplicate what is being done elsewhere. And this is something I would really want to emphasize at the stage where the ICSID reform or the amendments of the ICSID arbitration rules has entered into force in July. And as Ian was referring to, there's going to be a panel presenting these amendments. I would really like to emphasize the fact that we are working very closely with the ICSID Secretariat, particularly on the development of the code of conduct that we will be talking about later. But also, obviously, they are already and will be more and more involved in the development of the appellate mechanism, which, if you recall, is supposed to be transversal, to apply not only to the judgments of the first instance investment court, but also to arbitral awards rendered under the ICSID Convention, precisely with the view of bringing back the coherence that would otherwise be disturbed or further taken out of a system which is already in essence quite fragmented, because it stems from 3,000 more investment treaties. So what's important for you to bear in mind is that we are working with ICSID, for instance, as an example, but also with the OECD on another of our reform elements. And for instance, on dispute prevention, we'll be working closely with the World Bank. So wherever there are already these reform elements being developed, we are not going to redesign or redo our own little reform element. Let me take an example: mediation. What the working group has been working on so far is developing mediation provisions that fit into existing and future investment treaties, but not redoing mediation rules. Why? Because ICSID has just produced its own ISDS mediation rules, and so it doesn't make sense to have the working group in UNCITRAL repeating exactly what's being done somewhere else. And so the same is going to happen with the improvements that ICSID has just produced to its procedural rules, because the ICSID arbitration rules are arbitration rules, and the rules amendments that were focusing on cost and duration of the process will of course be taken on board to make sure that we don't end up with the UNCITRAL faster procedures and the ICSID faster procedures that go further apart. The idea is indeed, and that is always the direction into which the working group is going, is to build on what is being done so that we do not further explode and atomize, but rather bring together. So having said that, Maria Lucia indeed already presented the various elements that we have been working on. What I would like to focus on in my presentation is and because I'm pretty sure Lauren is going to speak about the code of conduct at some point or another, I would like to focus my presentation on the delivery mechanism for this reform. And this is to put together the different pieces of the puzzle. So what you've seen earlier are the institutional elements of, I should go to previous, the institutional elements of reform. One is this multilateral investment tribunal Maria Lucia spoke about. The other one is an appellate mechanism that is going to be transversal and also apply to state-to-state disputes at the request of some member states who are very keen on strengthening the state-to-state system, to investment arbitration, and to the first instant multilateral investment court. And then the advisory center that Maria Lucia also referred to. And then we have all the procedural elements, some of which you have already seen in the ICSID amendments. For example, security for costs or allocation of costs, or the possibility to bring counterclaims, or early dismissal of claims manifestly without legal merits. What are we doing here? At the UNCITRAL level, we're putting these elements into what will look like a chapter, an ISDS chapter in an investment treaty. Why? Is because if you don't have that in the treaty, particularly in the 3,000 old treaties that are there and that nobody wishes to reopen and renegotiate, you will never benefit from these upgradings and these positive amendments to the system that are being done in the ICSID rules, that we could also do in the UNCITRAL rules, except that ours are more generic and also apply to commercial arbitration, but that would otherwise be lost for the treaties that don't have them in the treaty themselves. So these are but a few examples that I'm putting out here to show you that, yes, there is already an ICSID approach to third-party funding, to early dismissal, to counterclaims, and of course, all of this will be included into the reform element as a replacement of existing provisions in investment treaties that are not up to this level of development in finesse and adaptation to developments in ISDS, because most of these treaties date back to the early 90s, where none of these issues were actually contemplated. But now let's talk about how are we going to deliver and to fit all these elements together. And in order to do that, and my colleagues are very good at animation, and I was hoping that I could do the putting together myself, but no, I can't. So let me just point at the different colors. In the center, you have what we call the multilateral framework convention. And this framework convention, we could have designed as encompassing as sort of a circle into which fit all the elements. But we prefer to look at it as the central piece of the puzzle, because the various elements of reform are going to fit into and to fit with the multilateral framework convention. But the reform will be achieved even if all the elements are not there, or even if all the elements are not subscribed to by all the states. So let me just go back briefly to the different pieces of puzzle. You remember my piece of puzzle, which is called Multilateral Investment Court. The Multilateral Investment Court fits very well with the central piece on the delivery mechanism. But if not all countries sign on to the Multilateral Investment Court, the system is still coherent and it will still be operational. Similarly for the appellate mechanism, similarly for the advisory center, which obviously is not going to be used by all countries, but will still be connected directly to the framework convention. So how are we envisaging this framework convention? We're not quite sure as yet as to the content of the framework convention itself. Will it have core provisions that apply across the board, or will it just be what it says it is for the time being, a framework that holds all the other elements together? That we're not sure. And we're not sure because what the states have been insisting on is keeping a degree of flexibility. And this has really been, from the beginning, oh, we want this reform, but we want it to be flexible. And of course, the understanding of what is flexible is not equally shared. And some states consider that, you know, the flexibility goes on, including into various provisions that are being negotiated, where they want to say, okay, I'm going to use this provision, I'm not going to use that, I'm going to use third-party funding, I'm not going to use double hatting, I'm going to use, so there can be a degree of flexibility that goes very much into the different elements of each piece of puzzle, but the flexibility can also be at the level of what piece of the puzzle do I add, do I plug into the multilateral framework convention that I'm adhering to. All right, so this is where I would like to just to finish, we're looking at a framework convention that will have the usual, you know, committee of the parties, that will be a mechanism to have all the parties continuing to monitor the way it works, including towards the future and future developments that might not necessarily be finished in 2026, when the working group is supposed to deliver its reform. And the other thing is that this framework convention, with or without its core provision, will have annexes or protocols. And this is the way we will link the pieces of the puzzle to the central piece. It will be through these protocol mechanisms. So either you adhere to the framework convention and one or two or three or seven different protocols that will be made available for states to adhere to. What we have to keep in mind, and that's where we're going back to my title with which I take issue, which is the fragmentation, is that we don't end up with a result which is totally impracticable, and which results in something which is blurred, difficult for investors to navigate. Let's not forget that the whole system we're talking about is meant to give certainty and to give reassurance and security to investors. So if you end up with a reform which is full of little pieces, and where you have to have a degree in neuroscience to be able to link what country has adhered to this and what country has adhered to that, or, I mean, if you don't have the degree in neuroscience, hire sophisticated lawyers to be able to tell you, if you invest in that country, this is what you will have on your menu. This is not the purpose. And we have a good example, which is the example of the reform of all the double tax treaties that has been undertaken by the OECD. We have now seen how it works. It has, of course, it is really a good template for us to know that you can tackle 3,000 plus existing treaties with a framework convention, which remains flexible for the states. But we also see now some of the defects in this, in too much flexibility, which results in having countries, you know, negotiating this and adhering to that, taking this, not taking that, and this makes it extremely difficult to navigate. So that's going to be our challenge. That's really very clearly where the working group doesn't want to go, into too much fragmentation, and hence our constant objective of making sure that all the reform elements as they're being developed fit and stick and remain together in a clear picture of the reform results. Thank you very much.
Thank you, Anna. And I think you're right that the multilateral framework convention is going to be the core element, because otherwise we will have just different pieces of the puzzles and not being able to how to it's going to work for all of us. Because so far we have been working in different texts, and we will talk a little bit more about that. But different texts, different parts of the puzzles. But then, if we are not able to really, the countries, I mean, the states, to really, join at least a core of provisions that is going to work for everybody, even if we need to be flexible first and to opt in some of the reforms, just as you mentioned with the multilateral court or the appellate mechanism, because we know that there we have divergence views in, within the countries, the states. So definitely for the meetings to come, we'll need to work in these multilateral framework conventions and to see how the other pieces are going to fit in this puzzle, either through protocols or to annex, as you mentioned. So one of these pieces of the puzzle that you mentioned is the code of conduct, and we have been working in the text now for several meetings. And actually, I was hoping, in the last meeting to finalize with the draft of the code of conduct, as I'm sure many other countries, but we were not able to finish or to finalize because there's different views regarding some of the topics. I would say that at least 85% of the code of conduct, we have a similar view. But then these other 15%, so it's 2 or 3 articles that are more conflict for some of the countries, and also for the potential impact on investors, right? One of these articles in particular have changed dramatically since the first version of the code of conduct, which is the multiple roles. We have had several versions of this article. It's Article 4 of the draft provisions. And so at first, and the secretary really did a really good work trying to differentiate the views. So those who are more for prohibiting or banning the double hatting, others more flexible, right? More flexible views, or some of the countries that really think that with disclosure from the part of the arbitrators will be enough, and then the parties will choose. So, and I believe that now we are like in the middle. So we are approaching, I think, a solution on this particular article. But I would like to hear it from Lauren, which is representing the investor side in these discussions, to provide, the view of the investors and how he sees that we could arrive to a final text of provision to this provision. Lauren.
Thank you very much, Margie. And as this is the first time I'm speaking, thank you to the organizers, Ian, Jose Antonio, the WOW founders and organizers, and also my co-panelists, including especially Anna. It's really a pleasure to be on the same panel with you and with the others here. In terms of the code of conduct, I think there's a lot of enthusiasm for the code of conduct in the working group. There's a widespread recognition that there's a gap in the international investment law framework, whereas there's no existing agreed multilateral instrument negotiated by states that sets out the rules of the road for arbitrators. Obviously, there are the IBA guidelines, conflicts of interest. There are other tools, but nothing negotiated by states, for investor-state dispute settlement. I will offer my investor perspective. I do want to make one sort of framing comment, though. In the working group, I do represent the U.S. Council for International Business, which is, as you indicated, on the private sector business side. I also represented the United States for 6 years as a delegate in the working group and also in negotiations. And I do try to mediate, I think, between kind of the investor perspective and the state perspective. As I'm saying this, I'm looking at my background where I have the sort of the green on the left and the white on the right. And I aspire to that kind of balance. I probably don't achieve it, I try, but my comments are informed by my government experience as well. That said, I do not speak for the US government in these comments. With respect to the code, again, a lot of ambition. I like the comment that you made, Margie, that we're 85% there and now we're in the toughest issues. Unfortunately, in my experience in trade negotiations, this is sort of how it goes, right? That you have a process where you make a lot of progress on the sort of the lower hanging fruit issues where there is general agreement or not significant gaps. But it's the last 15% really that is the most challenging, and that it's difficult to sort of predict how it goes, particularly in this forum, in an UNCITRAL forum, where you're seeking to achieve not just a sort of preponderance of views on one side or the other, you're trying to achieve consensus, which is a very difficult process. I think with respect to the code, in the most recent discussions in Vienna, my estimation is that we're moving more slowly than many delegates had hoped. And with respect to that remaining 15%, I'm not sure we see the end in sight yet. I don't know that I can answer the question that you posed, Margie, of how does this get resolved and when does it get resolved? I'll make sort of 3 points in terms of where I think the discussions were at the end of the meetings in Vienna on the code. I think, number one, I think most significantly, the working group has not yet bridged the gap on, I think, has been recognized as the most divisive issue in the code, and that is the so-called double hatting question. And depending on one's perspective, you can see sort of prevailing views on this side or that side, but I think clearly remains a significant divergence of views. Second, I think it's concerning from a kind of a process perspective that the working group didn't have time to discuss the whole code, that the code has 11 articles. And in this session of the working group, we reached 9 of them, didn't get to, for example, 2 very important provisions, one governing disclosure by arbitrators, which is complex and raises many policy questions. And then another article on how do you ensure arbitrator compliance with the code of conduct. And so not reached yet. And so as part of answering your question, Margie, it's hard to sort of project an outcome when there are 2 significant articles that have not been vetted in full in the working group at this stage. And then the third, and this goes again to sort of an incomplete perhaps, that the working group did not have the opportunity to address the commentary to the code of conduct, which is a draft document that was drafted by the UNCITRAL Secretariat that is meant to sort of guide the interpretation of the code itself. And that will obviously be a very critical document to sort of understanding how the code will operate in practice. And so that document, to the great credit, I think, of Anna and her staff, has been completed in its first draft, along with the ICSID Secretariat, I should say. But it's not been, and you can correct me if I'm wrong, Anna, it was not ready for discussion in the working group at this stage because it has not been translated in all of the UN languages, right? And so when you look at these 3 points, I think it's difficult for me right now to project with confidence that the code will be complete in July of 2023, which is when it has been projected. And that would be, I think, a major disappointment because this would be the second time that we've projected a deadline for the code where it would not have been met. The first deadline was in July of 2022. I want to be very clear. The delegates are working extremely hard on trying to bridge these gaps, both in Vienna, in informal sessions. The chair, the secretariat, there's enormous effort being expended to kind of break down these harder issues into kind of manageable chunks so that they can be, I think, addressed in this time frame. But I do think there is a question of can it be done? Can it be done, and can it be done in this sort of time frame? And I do want to make one comment on double hatting, but before I get there, I think there is a broader kind of issue in the working group that I'll discuss maybe later, and maybe others will have views on. There's just a lot of issues on the table and not a lot of time. And this is the the sort of where the rubber meets the road, right? That I think the challenge of meeting our deadlines in the code of conduct highlights this broader problem of an agenda that is really overloaded, and where, notwithstanding just enormous effort in formal and informal meetings by states, these are hard issues that require a lot of time. And how does it all get done? In the interest of getting it all done, do we get nothing done? I mean, those are the kinds of concerns that I have. Maybe on double hatting, just if I have a moment, Margie, just to say, again, I think there was a sort of a failure to bridge the gap between those who would like a kind of broad prohibition on double hatting and those that are interested in a kind of more narrow, tailored regulation of double hatting, including some, for example, prohibitions, but also kind of more disclosure. I will say that from my perspective, there had been a sort of decision taken in the working group that effectively the consensus was along the lines of a narrow, modified ban, so not a total ban. And the reason I say that is because in version 3 of the Code of Conduct, which was from the summer of 2021, there were these 3 options, right? There was a total ban, a so-called modified ban, and then a disclosure option, no ban, just sort of disclosure of double hatting. And that version was replaced this summer by version 4, the current version, which now only has one option effectively. There are bracketed texts clearly, but this version does not have a full prohibition. It has, I think, a modified prohibition that is intended to kind of identify what are the kinds of double hatting scenarios that raise the greatest conflicts of interest. And let's have a sort of per se ban in those areas. And outside of those areas, let's rely on the kind of background rules in the code on independence and impartiality, that there may be other circumstances not addressed in Article 4 where double hatting could be a problem under the rules. So that is where I think the group was. But the current text, I think, in the views of many delegations, while it does not include an explicit full prohibition on double hatting, I think the concern, and I do speak as a member or as USCIB representative and thinking from the investor perspective, I do think that the code functions, or the Article 4 functions, as a complete de facto ban. And I can get it, I don't want to waste time, and I know there's a lot to say here. I can get into all the reasons for that, but I think that's a widely held view. And there's a major sort of, is it a drafting problem? Is it a conceptual problem? It's very difficult for me to assess how the current drafting of Article 4 squares with what has happened before and the direction I think that I've seen in the working group discussing double hatting. Again, I'll pause there. I could say more, but I'll pause.
Thank you, Larry. No, and I think just with this little example, I mean, I know the audience can have these feelings of how the discussions are and how difficult sometimes is to for the states and the stakeholders to really get a consensus on some of the topics because different policies that they have. So I don't know, Lauren, for the interest of time, if there's another procedural matter that you would like to touch on, discuss, just to pick. I know we are short on time, but if you would like to address another procedural issue that you would like to discuss.
Before I do that, Anna, I see your hand is raised.
Oh, I'm sorry, Anna. Yes.
Oh, that's okay. But you said that it would be interactive, so
Yes, of course.
I'm being interactive.
You would like to reply, yes.
Interact with myself and with my colleagues. So no, I just wanted to make 2 comments on what Lauren just mentioned, and I'm not far from agreeing with you that the way the text has evolved has gotten us into this sort of difficulty to bridge the different positions, because on the one hand, we have this gardening leave that we are expecting from arbitrators who had a previous position as counsel, and where some countries have come from saying during 10 years thou shalt not wear another hat, and those who said let's not have any apart from the concurrent proceedings. So yes, there's, I mean, the gap has been already quite bridged in the sense that we're not talking about 10 years vis-a-vis zero, but that is one point I wanted to make. The second is that please bear in mind that it's the first time that the working group was discussing the code of conduct in person. Before that, we were all sitting behind our screens in 2D and not in real life 3D. And you don't negotiate behind a screen. You negotiate when you are able to sit down with colleagues in the cafeteria and chat about, take your pen and write things down. And the third thing I wanted to add, just following up on Lauren's point, is that this is how you build the buy-in. It's by allowing, and it can be very frustrating at times to hear people repeating the same thing for the same time, making comments for something that we have already moved on from. But this is how you make sure that the different delegations sort of internalize and buy into a process and will be able to go along. So if we don't allow this, of course, not very efficient regurgitating the same views or, just to have it said, but this is part of I would say the regurgitation is part of the digestion in some way. That's what I wanted to suggest. Thank you.
Thank you so much, Hannah. Thank you so much. Yes, Laurent. So there's so many procedural issues, actually, third-party funding, damages. I don't know if in 5 minutes, if you would like to address another of the topics. I know there's so many, but
No, absolutely. Thank you again, Margie. And I second all of Anna's comments a moment ago. And that was why I said that I think this is just the nature of the beast. And you added, I think, the important element, Anna, of this dramatic transition from, sitting in my bedroom for 2 years at 5 o'clock in the morning, trying to, negotiate these rules now into an in-person format where I think there's a lot of hope in the working group that the progress will increase now. And we're in a live laboratory to see if that is the case. I hope it is. With respect to the procedural rules, just one sort of framing comment and then jump into the rules. I, along with Margie and Anna, of course, we've been in this discussion now since November of 2017. And my perception, and Mary Lucia also discussed the sort of origins of this discussion. My perception from having been in this now for 5 years is, in the beginning, the discussion was largely kind of revolved around the idea of a multilateral investment court. That was one of the reasons why the working group was given a mandate in the first place by the UNCITRAL Commission to explore ISDS reform, because the European Union and its member states were interested in negotiating a multilateral investment court. And so a lot of those early debates were, if not explicit, sort of behind the curtain about this divide between those who support a court and those that do not. In my view, something has changed significantly over time, however, and the way that I would frame it is the EU opened the door and many other states sort of barged into the room with their own ideas on reform and their own priorities on reform. And for some, the court was not the sort of top of mind. And they have now, over the last 5 years, proposed a seemingly endless number of reforms. It's very hard to even group them into category to count how many reforms have been proposed by states. And they continue to propose new reforms, 5 years into the discussion. And so the recent discussions in Vienna, I think, were a case in point, that there were 2 long weeks of discussion. The court occupied less than 1 full day of those 2 weeks of discussions, and the remainder of the 2 weeks was focused on lots of other reform ideas. And here is the link to procedural reforms. So-called procedural reforms were one basket of the reforms that were discussed in Vienna. And here, maybe I'll just go right to the point of what do we make of the discussion on procedural reforms? There were 3 different reforms that were sort of the focus of this procedural reforms basket. Early dismissal of claims mechanisms. For example, early dismissal on the basis that a claim is manifestly without legal merit. Second, the allocation of costs in arbitration. And third, the issue of third-party funding. We didn't have time to discuss a couple of the other issues, procedural reforms that were on the table, including security for costs and counterclaims. So what to make of this discussion? I think I'll highlight, as I like to do, 4 points. One, a lot of enthusiasm, I think, on procedural reforms. Korea, the government of Korea had an intersessional meeting maybe last year that I think stimulated a lot of useful debate about how do you not just think about structural reform, replacing the existing system. How can we use tools, some existing tools and some new tools to improve ad hoc investor-state arbitration? And so I think there's a lot of enthusiasm for these reforms. That's my view. Second, I think there was agreement in Vienna on a number of key points on these procedural reforms. I'll highlight them. On early dismissal, I think there is general support for a mechanism. Again, what does it look like? Is it a draft treaty provision? Is it provision in a multilateral framework, as Anna indicated? I think that's unclear at this point, but something to allow states or tribunals to dismiss claims that are without legal merit at early stages that would look something like what the ICSID rules does, but perhaps different in some areas. On allocation of costs, I think there's general support for, in principle, as a default rule, having the unsuccessful party bear the cost of the proceedings. There was a very interesting discussion, I think, on, well, that is the in principle default rule, but what guidance should we give arbitrators when deciding allocation of costs? What kinds of criteria might they consider in making allocation decisions? I think there was interest in considering not just the outcome of the proceedings, but also the conduct of the parties, the reasonableness of the costs, and other factors. And third-party funding, I will not try to summarize it in one sentence, but I think it's a hard issue. In some ways, it sort of reflects some of the policy challenges that from the double hatting discussion. Sort of the states have strong views based on their experience. I think there was general support for continuing to permit third-party funding of claims for access to justice reasons and other reasons. There was also support for disclosure of the identity, the existence of third-party funding, the identity of the funder. And then there was this hard question of, okay, well, how do we regulate, and if we regulate or not? For example, the terms of third-party funding agreements. I think we didn't reach a consensus at all on that question. Moving quickly, so my third sort of takeaway, does the working group have the mandate to negotiate all these different procedural reforms on the table? This bandwidth question. As I mentioned, the working group was only able to address 3 of the 5 reforms that were on the table in Vienna. In addition, the working group requested, and I was looking at Anna and the Secretariat and wincing during this discussion, the working group members, the state delegations requested that the Secretariat undertake work on what I've counted to be at least 15 additional procedural reform topics, including, for example, binding joint interpretations by treaty parties, waiver, fork in the road, exhaustion of domestic remedies, statutes of limitations, go on and on and on. And I think negotiating these provisions, even if we're in now favorable in-person circumstances, will take considerable time. And yet we have this ticking clock, right? That we have many other reforms in addition to procedural reforms on the table. How can it be done? I will say from my perspective that I think prioritization is in order, that there needs to be a sort of difficult conversation at some point in the working group on figuring out how we're going to get sort of priority reforms. How do we identify sort of priority reforms, and how do we get those done so that we don't make the perfect the enemy of the good? And then finally, and this is sort of going back to Anna's comments about this issue of fragmentation or not, I think there is a sort of be careful what you wish for scenario here, that the vision of the working group is that we will negotiate perhaps all of these different reforms, meaning procedural reforms, structural reforms, all of it, code of conduct. But there will also be some significant flexibility for states to choose to opt into or opt out of some of these reforms. And in that context, I think I agree with Anna's overall point that if there is a multilateral framework, we can achieve coherence. There can be a sort of coherent framework in which all these different options and opt-ins are arranged. But as for whether we result in greater fragmentation or lesser, I think it depends upon a number of things we don't know yet in terms of how much flexibility are states, can states literally choose, there are 18 different procedural forms. I'm opting into options 1, 7, and 14. And within options 1, 7, and 14, I'm choosing option A of option 1, option C of option. There are some states, I think, that are desirous of that kind of flexibility. I think, in my view, that would create significant fragmentation. And then there is the broader fragmentation question of what about states that don't sign on to this instrument? That you could end up in a sort of those states that have signed on, those states that have not, and how does that play in terms of fragmentation? And so apologies for speaking longer than I anticipated, but that is sort of my take on this fragmentation question. And I think it connects directly to the procedural reforms issue because there are so many of those reforms on the table.
Thank you, Lauren, for the summary of the procedural issues. And the thing is that the mandate of the Working Group 3 is to work on procedural issues. And actually, in this past meeting, we had a whole discussion on a particular issue on whether or not it was substantive or procedural, because it has to be within the mandate. But also, and I recall this from these first meetings, there was a whole discussion that why we were focusing only on procedural issues and not on substantive issues, because there were substantive issues that needed to be reformed. But of course, this is taken by the unilateral, bilateral, multilateral reforms in the treaties. And for this, I would like to invite Katerina to comment on this, because, well, and she just published a book on contractual renegotiations and international investment arbitrations that I think it will be useful for these discussions on why procedural issues and why not substantive amendments, and how it could be fit, you know, the work that we're having at Working Group 3, and then also the work that are doing these states on substantive reforms. Katerina?
Thank you very much, Margie, and thanks a lot also for making a reference to the book. That was very delightful to listen to all those presentations. I'm a bit of the elephant in the room because in a dual hatting even, because I'm both an academic and I will not focus on procedure, which I find, of course, very important, especially frivolous claims and third-party funding and all the issues that can create perverse incentives for the use of the system, because let's remember that after all, it's a system to deliver justice and not to be gamed for other purposes. And I am very supportive of all those procedural reforms on frivolous claims and third-party funding. I believe that it's great that the working group is doing so much good work on dismissing the claims that are frivolous at an early stage, and even to provide an expedited process for that. I think that it's also great that there is a link between frivolous claims and third-party funding. We can see, for example, in the case, of course, of the revised exit rules, a similar trend in the CETA, like in, as you said, in individual treaties, there is this trend of dismissing frivolous claims. And the working group in UNCITRAL has even made, I believe, third-party funding a potential factor to consider while assessing if a claim is frivolous. So I think this is all very good news, and it kind of starts linking up to substantive issues. I understand, of course, there's so much on the plate of the delegates that it's hard to address both procedure that is already very loaded and substance. But I want to pick up on Anna's very positive, optimistic multilateralization note and say that I kind of believe that the Multilateral Investment Court bears some similarities with the Multilateral Framework Convention, in the sense that they're both frameworks that can foster some multilateralization. It depends, of course, on how they will be implemented in the end. But I think that there is some potential from the Multilateral Investment Court to lead to further multilateralization. That said, of course, before I offer to you my own take on things, I would like to thank very, very warmly the organizers for inviting me to this great panel. It is really a pleasure and an honor to be with such great experts and great colleagues of international investment law. And I would like to thank also very much Esme Shiglo and Kira Nasir Gore, who put together this amazing book. Perhaps we can show some material and now or also in the chat if you want. So it's out and it's a great book. I contributed a chapter that I'm going to present very briefly to you today. And it brings a positive note about the Vienna Convention on the Law of Treaties and how it can help prevent further fragmentation of the system, how we can actually gouge old rules for new problems, how we can use the very well-established rules of the Vienna Convention to address some problems that we are facing now in ISDS reform. So this book celebrates the 40 years from the entry into force of the Vienna Convention on the Law of Treaties. And indeed, it addresses the role of the VCLT in investor-state dispute settlement and explores the tools that the treaty offers to throw more discipline to this field that is still, let's face it, under development. So my question, because as an academic, I can, I guess, be a little bit provocative, picking up on the offer, on the proposal of the host to be a bit provocative. And I'm asking the question, are procedural rules enough to address the so-called legitimacy crisis of ISDS that has been going on for quite a while? I believe that they're, as I said, they're very important, but I wouldn't say that they're enough. And in my chapter, I am adopting a policy approach to ISDS reform, saying that we need to focus a lot on the inconsistencies in the interpretation of investment treaty standards, because we have seen arbitral tribunals have interpreted in very different ways standards that sometimes have the same or very similar wording across different treaties, or even sometimes based on the very same treaty. So we need to be reminded that the current options for reviewing arbitration awards, annulment and set aside proceedings are limited in terms of going into the merits of the case. They do not. So they engage in a limited review on the basis of inconsistent or incorrect decisions that are designed to look into procedural deficiencies, major procedural deficiencies. So the Multilateral Investment Court, I believe, could present an opportunity to address those interpretative inconsistencies, and the Vienna Convention could offer the tools, the interpretative tools, to achieve more consistency. And how can this be done? This can be done, I believe, through a multilateralized and evolutionary interpretation of the relevant investment treaties by focusing on the specific rules of the VCLT that provide for an emphasis on subsequent agreements and subsequent practice of the parties. What I find quite peculiar about the Multilateral Investment Court, the MIC, is that even though it purports to cure decentralization and the resulting interpretative inconsistencies, intrinsically, its development is also based on a series of bilateral agreements that include the so-called investment court system that I believe in the end, is covered by the framework of the MIC, the different ICS mechanisms included in different treaties covered by the overarching framework, so-called agreement on the MIC. So how can the establishment of the MIC through the gradual centralization of the ICS systems into the Multilateral Investment Court guarantee interpretative consistency, since we will have various awards that different ICS tribunals will have rendered in the meantime? And I believe that we can do that by looking into the VCLT and subsequent agreement and subsequent practice. This can be done through a network effect of the treaties, including the ICS mechanism, as a first step towards establishing the MIC. And indeed, there has been a heated debate also in academia about multilateralism versus bilateralism. Professor Schill has talked about a de facto multilateral framework. He has said that even though we have this bilateral structure of various treaties, essentially, in practice, tribunals act as if there is an overarching body of law, of international investment law. In contrast, Professors Mitchell and Monroe have been more in favor of bilateralism. In what sense, though? In the sense that they point to deficiencies in this systemic perspective of integrative interpretive methods that justify taking into account third-party international investment agreements when interpreting an investment agreement. So Professors Mitchell and Monroe have written a great article on the use of third-party investment agreements to interpret the agreement that the tribunal has in front of it. And they say that we need to be cautious about that because they're agreements that represent a significant great break from the past, like CETA, for example, the European Union-Canada agreement. So as mentioned, the MIC follows the reverse path of multilateralization compared to the previous decentralized regime of ad hoc adjudication, where we have one-off arbitral tribunals that are based on bilateral treaties, and they engage in cross-treaty interpretation as a de facto way, as Sheil has said, to promote multilateralism in ISDS. Here we have upfront with the MIC multilateral planning, but it is still aspirational. So it has an aspirational and evolutionary character because it is a commitment that is included in a series of bilateral investment treaties that provide for the investment court system. So since the MIC results from the shared interest and intentions, going back to what is the intention of the parties to the treaty, to promote the evolutionary interpretation of the treaties that are under this framework of the MIC, this framework convention. What do we do to promote this multilateral and evolutionary interpretation of the underlying agreements, providing for the ICS? We look into subsequent agreements and subsequent practice. For example, we can see already the CETA parties have issued joint interpretative instruments, so subsequent agreements in the sense of Article 31 of the VCLT, that authorize the parties to issue subsequent binding notes of interpretation that will indeed bind the tribunals and operating under CETA. And apart from, I believe that could be even more innovative, apart from those unequivocal subsequent agreements of the parties to the treaty, the question is about the role and legal effect of the so-called subsequent practice of parties to treaties providing for the MIC. So what kind of subsequent practice could establish the agreement of the parties that falls under the general interpretative rule of Article 31 of the VCLT? As the MIC is an overarching multilateral framework system, we need to look into subsequent practice in a wider way, meaning that the question is if, for example, the EU engages in subsequent practice in its EU-Vietnam investment treaty, does this subsequent practice potentially bind the EU also in a third-party treaty that endorses the MIC as well, for example, the EU-Singapore investment treaty? So a question is whether such subsequent practice could establish the agreement of the parties to the third-party treaty with regard to the interpretation that is given by the parties to the other treaty providing for ICS. I also believe that since the VCLT does not specify what type of conduct qualifies as subsequent practice under the VCLT, we need to look into the draft conclusions of the International Law Commission of 2018 that say that it's not only active, but also passive, let's say tacit practice that qualifies, tacit conduct that qualifies as subsequent practice. And in that way, we also need to look into the practice of the MIC itself as an international organization that the parties to it have delegated authority to. So to summarize, how would I propose to make this network multilateral interpretative effect of treaties providing for the ICS as a first step towards the MIC operational? I believe that a way to do that, to look into the interpretation given in subsequent agreements and subsequent practice across the board in the various treaties providing for ICS and leading up to the MIC, is to possibly include a provision in the MIC statute saying that for matters of systemic importance under treaties falling under the competence of the MIC, non-disputing third parties should be consulted, both in the course of a dispute and in reaction to a joint interpretative statement issued under one of such treaties. And if the third parties do not react to the matter consulted upon within a certain number of days, a period of time, their silence could be construed as tacit acceptance of the tribunal's interpretation or the party's interpretative statement on the matter concerned. As I said in the beginning, this is a policy paper, it looks into potential ways of incorporating evolutionary interpretation into the system and bringing more consistency to the interpretation of investment treaties operating under the MIC that still has a bit of an aspirational nature. So thanks a lot for your attention, and I look forward to engaging more with all of you.
Thank you, Katerina, for sharing your views and the absolute content of your book. Unfortunately, we are without of time for more discussions. I would just like to share also, I have a chapter on a book that is on the investor state dispute settlement reform, replace, or status quo. So it's also a very provocative title of its reform, replace, or status quo. There's a chapter, it's also published on Walter Kluwer in case of interest. But with that, I would like to thank our panelists and the organizers. It has been wonderful to share with you, to discuss all these hot topics. And I'm sure that there will be more discussions next year. Hopefully, we could celebrate that we have a code of conduct approved for next year. So that is a goal for next year. So Jose Antonio, I don't know if you want to share some final words, remarks.
Yes, indeed. Thank you very much, Margie, and thank you in the order that I see you, Ana, Maria Lucia, Lauren, and Katerina, and hopefully that I hope that I did not say it as badly as I said it in the beginning. So it was truly a pleasure to hear your comments, and also I'm amused but glad that the the one concern that I believe many may have in their minds, or at least one of the concerns was straight on addressed in this panel, which is whether we will hopefully end up with a cohesive opt-in, opt-out structure, or whether we might default into a more difficult to address fragmented system, and it is a challenge. It is an enormous challenge in a data and age where really all the stakeholders are at the table. I mean, there might have been a time in international relations where not all the stakeholders might have been in the table, but my general sense is that at the UNCITRAL Group 3, we have business, business groups. We have the states. We have so many stakeholders. Of course, I mean, everyone wants to have a greater voice, but I think that there has been enormous work by the states and by the Secretariat to create legitimacy. And that is very difficult to manage in the middle of the pandemic. So it's not an easy task. So in any event, I would like to thank the presenter, Maria Lucia. I think that you did set the stage in a great manner. Lauren, thank you for being candid as to the challenges, and also putting the focus on some of the challenges concerning the code of conduct. Hopefully that 15%, the 15% or the 5% or the 2% or the 1% is always the most difficult part of any negotiation, and I talk from experience. I mean, it's I'm not surprised, and let alone negotiations with 100 and plus number of other parties. Katerina, thank you so much for bringing sort of the more sort of reserved thoughts about how to deal with a system that may have different levels of obligations by many. My only sort of reaction to your suggestion is that clearly it seems that we would be moving, if adopted, that type of suggestion, we would be moving from a system where now we are in ad hoc tribunals whose awards are strictly inter partes. We would be moving into a system where the decisions, the judgments would have a systemic effect, and hence your suggestion for giving way for non-disputing parties to have also their words or their voice. With that, this is a session that would be a lot of fun to have a breakout room. I'm not discarding it. We may want to meet. Maria Lucia can manage that. I unfortunately won't be able to stay during the breakout room. I invite all the panelists to stay in the breakout rooms. A lot of things happen, but I won't be able, because I have to go to our next session, which is the in-person ICSID amendment rules session. And it's not, I'm not in there, so I'll be running between places in Washington, DC. And thank you so much. You will be seen in the publication of the video. Bye-bye. And feel free to stay in the breakout room, and Maria Lucia will manage it. Bye-bye.